we have almost solved it. So we can begin. Uh, Hello everyone. Welcome to today's session. Today it is my great pleasure to introduce today's distinguished speaker, Professor Antonio Sandu. Professor Sandu is a tenured professor at Stephen Selmer University of Suceava in Romania and a senior researcher at the Lumen Research Center in Social and Humanistic Sciences in Latin. He also serves as a visiting professor and PhD advisor at Purdue University and is the CEO of Lumen Publishing House. With a prolific academic career, Professor Sandu's work spans ethics, bioethics, sociology, social work, social philosophy, and public administration. Professor Sandu is the author of more than 20 books and he has published over 100 articles, 45 of which are indexed in the Web of Science, and he holds an H index of 10. And also, it is my great pleasure to inform you that he is the adjunct professor at our campus, Chandigarh Group of Colleges, Jhanjeri. So it is our wonderful pleasure to have him on board and deliver a wonderful session to you. So over to you, sir. Thank you.
Hello, and thank you for this wonderful presentation. As you said, I'm Antonio Sandu, PhD professor at Stefan cel Mare University. But yes, who am I? As our colleague says, I am a tenure professor at Stefan cel Mare University from Suceava, Romania, and also I'm a visiting professor and PhD advisor at Oradea University and the CEO of Lumen Publishing House from Iași, Romania. Let me present this also with this presentation also with PowerPoint because you could also see what I speak to you, what I say, not only here, but if you do not, if I'm not present very clear and you do not hear very well my words, my speaks, you could read this presentation and you could understand, I hope, better than if you just hear my voice. So so can you see my speech? Can you see my presentation and hear my speech? Can you?
Yes, sir. It is audible and visible.
Okay, thank you very much. Indeed, my main areas of interest include ethics, bioethics, sociology, and social work. Because my first love, as academic love, as I could say, was philosophy. I'm developed my career starting from philosophy, but also from the other areas, sociology, bioethics, and ethics. And the original contribution I was made was starting from social construction of reality and social constructionism. The idea that in this social constructionism is that the reality, mainly in the social field, is not something stable, but is the results of a perpetuous, a permanent interaction between communicative communicative actors. I could operate on this paradigm, and this was this will be the paradigm in which I will present also this lecture, this presentation. I studied the interpretative drift of ethical concepts such as ethical acceptability and ethical values. And in this presentation we will study the idea of informed consent and informed consent as a basic idea for respecting the autonomy of the person in medical area or in scientific research area, all starting from sociological and legal point of view. I also conduct research on autonomy and informed consent, as we will see, in medical ethics and public health ethics. I'm also interested in transhuman and posthuman changing in human condition due to the virtualization of social space. This social space virtualization is the transference of the social interactions from physical space, from physical area into virtual one. So I can speak to you. I'm in Romania, you are in India or abroad or wherever, but you can hear my voice, you can see my face, and we can interact as we are face to face. So it's this phenomena we call virtualization of social space, because many social interactions are actually virtualized, not only the learning problem, but many others, including medical action, even religions action, and so on. I'm author of the book Bioethic in Crisis, or The Crisis of Bioethic. You can find it on Amazon if you like. And Anthropology of Pandemic in Medical Health Society. But this book is in Romanian, not in English. And I'm also authored Social Construction of Reality as Communicative Action in Cambridge Scholar Publishing, also available on Amazon. Also, I was working social work practice, so you can see and read eventually my book also in Amazon, and I have some articles that you can find in open access journals, so you can just type my name, Sandu Antonio, and you can find my papers in Scholar Google or in another databases, so you can know me in my writings if you are interested in, if you will like this presentation. In this presentation called Legal and Moral Landmarks of Informed Consent in the Context of International Human Rights Law, we will analyze the concept of informed consent from a bioethical and legal perspective, and we will highlight its due role as a decision-making process and also an administrative tool in the context of medical practice and human subject research. Informed consent is examined as a distinct legal institution in the process of formation within international medical law, created to ensure respect for the right of patients and the research subjects, especially in a situation involving potential restriction on the individual freedom. This informed consent is currently used in medical relation between doctor and patients, but also in research on human subjects. But it could be extended in other fields such as information and communication, and protection of privacy on internet and all area that new science, new emerging sciences put this provocation in front of us. Just a second. Within this presentation, we will make a series of statements with the purpose of clarifying the legal nature of informed consent as an unilateral act specific to the medical field, but distinct from a simple condition of validity of the legal act as the consent is viewed in civil law. So in our law, in European and Romanian law, the consent is general. It's a general obligation for validity of a legal act, of a contract, for instance. But we consider that in medical practice, in medical law, for instance, and also in scientific law, in law of scientific research, more specific, informed consent become more than a simple validity requirement, but is a special juridical institution that is informed consent per se, and have the nature of a unilateral act, such as the testament is also an unilateral act, where a person says something, this person should receive my fortune, my entire fortune after I die, or this doctor this doctor is accept to operate me, and I consent that he do this in good condition, and even if he kill me because I die in the surgery, he's not liable of this situation, because I ask him and I consent him to do this operation, for instance. So it's a special kind of juridical act, and it's unilateral. Yes, it involves the obligation from the part of the doctor too, but we will see how what type of obligation will involve. This potential tension between decision making and administrative role of informed consent in medical practice is highlighted by us. So this informed consent is not only an act that we sign in Europe, in the United States, and I hope in India too. When we go to the doctor, they say, yeah, you should consent, you should accept this and this and this. You are in this condition, and we give you a treatment. We give you a surgery, make you a surgery, and you should accept. And in our country, the patient should sign this agreement as an act, as I say, an unilateral act that accept the physician to do to do his jobs and perform this operation. But also is a process in which the patient receive the information from the physician, what is his condition, what is the diagnostic, what risks are involved by the procedures, and so on. So it's the two component, the administrative act that the patient is mandatory to sign, but also this process of give the information to the patient. So informed consent is a process, as I say, in which a participant voluntarily confirm their willingness to participate in a particular action, mostly medical or scientific, after having been informed of all aspects relevant to their decision. It encompasses comprehension of disclosed information, voluntary choice, and explicit authorization, ensuring ethical conduct in research, medical procedure, and data collection. From the perspective of legal relation in healthcare, informed consent represents the central instrument in protecting the rights of patients and participants in biomedical research. Also, informed consent is seen as an administrative act. Informed consent as an administrative act is a formalized procedure within institutional framework that documents a subject's voluntary agreement to participate in a study or undergo a medical or psychological procedure. It involves standardized protocols for information disclosure, verification of understanding, and official documentation of consent, adhering to regulatory requirements and institutional policy to ensure ethical compliance and legal protection. So, legal and moral landmarks of informed consent in the context of international human rights law. We will briefly analyze the alternative form of consent, such as dynamic consent or delegate consent. This delegate consent is when other person give consent in the name of the patient that are unconscious state, for instance, or for underage person, and his representative persons give the consent. And dynamic consent is when we do not know exactly. For instance, in a research, we agree that the physician take our blood for analysis, but we also agree that this blood will be used in scientific research from our sickness, from our medical condition. But we also agree that in the future this blood sample or tissue sample could be used in another research, but we also can withdraw our consent. This is the dynamic consent. In this presentation, examine the relation between patient's autonomy as a central ethical value and the practice of obtaining informed consent in the context of fundamental human rights. For instance, we consider that autonomy, the right to autonomy, is the central value in medical, in this kind of medical practice. What is autonomy is the exemplification, is the way we express our liberty. So it's what we call expressive autonomy. So I can do what I really believe that is good for my health, is good for my condition, even this could harm in some way my body, because it's necessary for a greater good, such as an operation is necessary but harm in a specific way my body, but is necessary for my future benefits. So this autonomy is the way I express my acceptance and my will and my capacity of consent. So this informed consent is the expression of this autonomy in medical and research field. Also, we can distinct between the concept of freedom and autonomy. There are fundamental many interpretations for I mentioned and applying norms in the medical sphere. Our study offers a comprehensive analysis of informed consent. Our study is way bigger than this short presentation. It will be a book, a whole book on these subjects, but maybe at the end of the year, and you can see this on Amazon and on other bookshops and so on. The study will offer a comprehensive analysis of informed consent, and we will highlight its legal and ethical complexity in the context of contemporary medicine and human subject research, while also proposing a direction for improving the legislative framework and current practices. In this presentation, I will not present the improvement of legislation because we live in a different country. So this legal improvement is mostly for Romanian legislation, but maybe this could be applied in Indian legislation too, or in another country legislation also. Informed consent constitutes the axiological and normative foundation for the protection of human rights in the medical and the bioethical research context, evolving from a simple notion of civil law to an essential instrument in human rights protection. What's important? So we stress and we state on the axiological perspective. It's what is our value and what's the constitutive value that's require informed consent, and we consider that constitutive value is that the value of autonomy, but we have also operational value, the value that guide us how to obtain the informed consent, and this value should guide the medical practice or the scientific practice, and for instance righteousness and protect of the patient and of the subject and their liberty and their right to be informed and so on are these operational values of informed consent that show us how to apply this instrument. That instrument are come to realize the main value, that is respect for the patient autonomy. Examining the philosophical origin of the concept of autonomy, we can trace a line from Kantian thought, which postulate autonomy as the source of human dignity, to contemporary interpretation that incorporate elements from post-Kantian and utilitarian theory. We can highlight the transition from a transcendental vision of autonomy to one that takes into account the contextual factors such as emotion, personal value, and social circumstance in the decision making process. So I mentioned before that we consider this informed consent as being a social construct. So in current society, in our Western part of thinking, we consider that such thing as informed consent is mandatory and represent the respect of the human right, but is not something that are forever in medicine. For instance, in Hippocratic oath, they say primo non nocere, first not do harm, but in bioethic there are many do not do harm is one of the bioethical principle, but not only to do good and also to respect the autonomy and also to respect the social righteousness is also mandatory for medical and bioethical practice. That's why we consider, because this the meaning, the sense of this notion of informed consent is changing through time, and this interpretative adrift from what the consent represent in civil law, for instance, and what is represented now in medical law. It's an interpretative adrift, so we consider that is a social construct, social constructed also in the context of medicalization of social life. So this informed consent is a construct that derived directly from the medicalization of social life. Informed consent is presenting as a legal expression of autonomy, representing an unilateral act through which the patient or research subject express agreement for a medical intervention on participation in a study. The legal instrument goes beyond the mere procedural formality, constituting a complex process of communication and deliberation between patient and professional. So not on, we consider that this informed consent obtaining process should not be only a presentation from a part of a physician, this and this and this, but also a process in which the participant, the patient, is not only informed but encouraged to take his decision in the context of his family, of his life, and of his revenue, because some treatment costs more than others, and some people do not have the resource for this treatment, and so on. We pay particular attention to the evolution of the concept of informed consent, as we mentioned previously, in international law as well in European law, and particularly in the European Union, because Romania is part of the European Union. We have analyzed the legal instrument from the international human rights protection system, such as the United Nations Chart in 1945 and the Universal Declaration of Human Rights from 1948, the International Convent on Civil and Political Rights, and the International Convent on Economic, Social and Cultural Rights in 1966, and the United Nations Convent Against Torture, or the United Convention on the Right of Person with Disability, and the Declaration of Helsinki. Those are a legal framework for informed consent on the international levels, and from these acts, international acts, the national legislation of informed consent should be informed and should based on the international reglementation, international regulations. It's important because the idea of informed consent is not only something that that could be prioritized in the national legislation, but also could be understanding as a main instrument to protect the rights of the patient, the right to live, the right to health, and other rights that could be used. And this ethical principle that is present in the declaration, in all declaration, but we quote from Human Rights Declaration, is and we transfer these principles in principle 4 informed consent is respect for subjects. This means that their participation in research or in therapy must be voluntary, based on informed consent. This voluntary should not be, for instance, a mandatory participate. Of course, exists mandatory treatment for mental illness or on the patient that are in some special situation where they are put in mental institution by the court law, but and they have to be treated for and they have to take some medication for their mental illness. But otherwise, if there is no law, if no court of law decision, the patient should not be obliged to take a treatment that he did not want, or a subject could not be obliged to participate in research on human subject, neither if he is in the prison or he is paid with money or obliged by their own family. But no mandatory, no obligation should be upon the participant. The information that the subject must receive include the purpose and the procedure of the research, the risk and the benefits involved, but both for themselves and for scientific evolution in general. Possible states of discomfort that could arise both during the research and the subsequent period must also be presented. The institutional affiliation of researchers, for example, and defining source of research project must also be presenting to participants, rather for ethical reason, avoid conflict of interest, that protection or also for protecting human rights. Why? Because if I have a religious belief that, for instance, some research are not ethically or not in line with my religious belief, I should not be allowed to participate in a research that contradict my spiritual or intellectual or other values that I adhere to. I could not be obliged to participate in a research that violated my basic beliefs. The person's right to refuse to participate in research or to withdraw from research in any time must be clearly presented to the subjects. Benefits and risk involved in research. Of course, for research involving human subjects to be ethically acceptable, it must have a significant potential health benefit, and we are talking about both the health of research participants and especially potential future benefits of research results, and the risk assumed by participants should be minimized and justified by the anticipated benefits. That's because a participant in the subject research is sick, have an illness, is a sick person, and this participate should be a hope for the patient, but he could be part in a placebo control group and not in the experimental group. So the value should be more important, the value of the results, and not for the personal value for participant, but this also should exist and should be expressed in agreement and in informed consent. Ethical review. Study must receive approval from an independent ethical committee, which ensure during the evaluation that ethical standards are respected and subject rights are protected. The ethical principle present in the declarations, not only in this Universal Declaration of Human Rights, but also in all other declarations that we mentioned previously. The safety of the subject, the priority of the subject's well-being, and safety through the research is essential, with the researcher having the obligation to intervene if adverse effects are reported, eliminating the research participant who manifest these adverse effects, or even immediately stopping the entire research if the situation requires it. Honestly, in publishing and disseminating results, whether positive or negative results, should not be hidden from the scientific community. This should be published to contribute to the advancement of medical knowledge and to ensure transparency. Informed consent also represents an important element for protecting individual autonomy and the right to life and dignity in the system of Council of Europe, highlighted in normative acts such as Convention of Oviedo, and also in the protocols to the European Convention of Human Rights and Bioethics, the Oviedo Convention, and implicitly in a particular decision of the European Court of Human Rights. We will not present in this presentation the decision of European Court of Human Rights, but it will be included in the book. So if someone is interested in this decision, you can find it in the future book. This Oviedo Convention, we present this convention, and we mention some aspects regarding informed consent contained in the Oviedo Convention that was adopted in 1997 and represent a fundamental document in protecting human rights and human dignity in the biomedical field and in the research on human subjects. The key principles of this convention include the primacy of the human being over scientific or societal interest, the equitable access to quality medical care, the obligation of informed and free consent for medical intervention and research, special protection of vulnerable persons, minors, persons with mental disability, the prohibition of discrimination, and the prohibition of using the human body or organs for profit. The Convention stipulates that any medical intervention requires free and informed consent expressed in writing. That's why we mentioned previously that this informed consent become an administrative act and administrative document, because this Oviedo Convention, in which my country, Romania, is part as many of European countries. The information provided must be complete, correct, and adapted to the person's level of understanding. Participating in research must be voluntary, and the research project must be approved by ethical committee. The document introduced the concept of informed consent as a distinct legal act designed to protect the rights of patient and research participant. The convention also addressed specific aspects such as prohibition of creating human embryo for purpose of experiment, limiting organ removal from person incapable of consenting, or not only limiting but forbidden, regulation of post-mortem organ donation. And this is important because it's regulated also the European Union legislation, European Union framework legislative framework. At the European Union level, the Charter of Fundamental Rights of the European Union was presented from the perspective of how it was contributed to consolidating informed consent as an instrument for protecting human rights and the medical context. The term consent has a singular presence in the Charter in the context of Article 3, paragraph 2. Dignity, the term consent appears in the context of discussion on the right to personal integrity, imperatively established to free and informed consent of the person concerned, but is important that connects this right to autonomy and obligation of having or giving the informed consent in medical practice to the human dignity. The idea of consent appears in the context of medicine and biology, but it appears in this domain, but could be expressed in all other and used in all other domains where human dignity is an important value. We highlight the importance of the voluntary nature of the informed consent, emphasizing the need for the absence of any form of coercion or unjustified influence. We make a comparison with classical consent in civil law we mentioned previously, showing that in this case of informed consent, the burden of proof regarding the validity of consent falls on the medical professional or researcher, not on the patient part. In the court case that we analyze and discuss in the big research, we see that the medical part, the physician was asked to demonstrate that they have this written consent from the part of the patient. Informed consent has evolved from a simple concept of civil law in contract that we mentioned to a particular type of complex legal act specific to medical field and biomedical research. This evolution of the concept of informed consent reflects a fundamental change in approaching the relation between patient and subject and medical professional researcher, replacing the paternalistic model with one centered on individual autonomy and self-determination. That's why we speak about this social construct and character of informed consent. Health is defined in the legal context as a fundamental right of the human being protected by both domestic in Romania and international legislation. The World Health Organization definition extends the concept of health beyond the mere absence of disease, including physical, mental, social, and also spiritual well-being. The medical-legal relationship can be analyzed as a complex social relationship regulated by legal norms in which the involved parties, doctor and patient, are holders of reciprocal rights and obligation. Attention can be highlighted between the contractualist perspective on the doctor-patient relationship and the perspective that view this relationship as arising only from the legal obligation to provide treatment. The medical-legal relationship contains both subjective rights and correlative obligation for both parties involved. Hence the contractualist nature, which however contrasts on the other hand with the unilateral character of the legal acts, as we mentioned previously, of informed consent, and on the other hand which with the lack of the doctor's obligation to treat the patient in a manner desired by the patient, in accordance with good professional standard and legal obligation. Obtaining informed consent is, on the other hand, a process and not just a legal act. The the latter representing only the unilateral consideration of the results of the information decision, information deliberation, deliberative process. So the idea is that this relationship is mandatory for the treatment, but doctor should not have an obligation to result, because somehow patient could not respond to the treatment, and we cannot ask from the doctors to treat to cure a disease, but to treat the patient in the best way is accessible and possible in the situation in which the doctor and the patient are in this particular relation. Informed consent is presented as an essential legal instrument in protection patient rights, going beyond the simple function of exonerating the doctor from liability and representing a guarantee of respecting the patient autonomy and right to self-determination. There are various forms of autonomy, rational, expressive, relational, and each of these represent a way in which they influence the process of obtaining the informed consent. So usually we consider autonomy in a rational perspective. I, as patient, was informed by my condition, by the treatment, the risk, and the results, and I am free to decide about my condition. So I take the decision to perform a treatment or to refuse the treatment, and this is the rational autonomy. But the expressive autonomy intervenes when I say, well, this medical doctor, I do not believe in this kind of treatment. I prefer, for instance, your Indian old medicine, Ayurveda, instead of contemporary Western medicine, because I most believe in Ayurveda than in Western medicine. So it's my expressive idea, my expressive autonomy. And relational autonomy is when, yes, I'm a diabetic patient, but my whole family should have money, should have means to live. So I could not afford myself to give such money for the treatment, for the pills, because I have obligation for my family, to my family, and I cannot afford a specific treatment. One of the most important challenges in implementing informed consent is the need to adapt information to the patient's level of understanding and the medical professionals' effort to ensure that the patient makes a truly informed and voluntary decision. In this context, we highlight the importance of informed consent as a continuous process, not just as a punctual administrative act, because the patient is not a doctor, the patient does not know the medical jargon and the medical language, and patient is somehow do not know what cancer represents and what kind of cancer he has, and what is the prognostic from his illness, and so on. And the doctor should explain all of this to him in a language that could understand in his own level of understanding. The issue of medical liability can be approached by analyzing the difference between the obligation of results and the obligation of diligence in the medical act. As we previously speak, the obligation of results is, well, I expect from the doctor to cure me, but the doctor could not cure me in any situation. but his obligation is the one of diligence. He's mandatory, he's obligated to do what he could do best in scientific reason, in the cultural and hospitalization context, in context of the research that he have to treat and all of this, but he has this obligation to do diligence to treat me in the best way he can. This has a concrete implication for the evaluation of medical malpractice and the professional fault. Is informed consent a contract or an unilateral act? As we mentioned, we consider an unilateral act, but critically analyzing the contractualist approach, because there is in juridical literature the idea that medical relation between doctor and patient could be based on the contractualist approach to the the contractualist approach to the doctor-patient relationship. We argued that although there are contractual elements, informed consent transcend this perspective. We emphasize its nature of unilateral legal act, which forms the basis for establishing a contractual type of relationship without being confused with it. This distinction is essential for the correct understanding of the legal nature of informed consent and its practical implication. The issue of medical liability can be approached, as I mentioned, as the difference between the obligation of results and the diligence. We mentioned we do not stay on this idea because we also discussed previously. But informed consent represents an unilateral legal act. It was my conclusion, through which the subject expressed informed agreement for intervention that may affect their body integrity or even life. Special attention must be given to the patient's right to information and to the doctor's correlative obligation to inform, obtaining the limits of the right, as well as situations where the doctor may withhold certain information in the therapeutic interest of the patient, because some patient is in the special condition where if the medical doctor informed completely, that could make harm him or her in this process. So the medical doctor should know this and should not inform totally, and should inform but in a special way in this case. The importance of effective and adapted communication between doctor and patient must be emphasized to ensure truly informed consent. Through the analysis of relevant jurisprudence, as I mentioned, to the European Court of Human Rights regarding the informed consent and the right to privacy in the medical context, significant cases can be highlighted that have contributed to clarify and developing the doctrine in the field, making the complexity of legal relation in the healthcare and the crucial importance of informed consent as an instrument of protecting patient rights. This justifies the need for a balanced approach that takes into account both patient autonomy and the professional obligation of the doctor and the public interest of health. Few conclusions. A fundamental finding of the study is the transformation of informed consent into a distinct legal social practice derived from classical consent in civil law, but adapted to the specific of relationship in the medical field and in the field of human subjects research. This evaluation reflects a growing recognition of the importance of individual autonomy and the need to balance power relationship between professionals and the beneficiary of their service. We highlight the importance of understanding informed consent not only as an expression of rational autonomy, but also as a manifestation of subjects' expressive and relational autonomy. This nuanced approach recognizes the complexity of the decision-making process in the medical context, taking into account factors such as personal values and the patient's social and cultural context. And if you have any questions, I gladly answer it to you. And thank you for your patience and for participation.
Thank you so much, Professor, for such an insightful session. And we have received a few questions in the chat box, like the participants can send it to us, and I will read them out to you for seeking the answers. So the
Okay.
first one is, can informed consent be waived in emergencies or national security contexts under international law?
Yeah, this is an interesting question. Yes, in emerging situation, a patient could not consent, and there is a presumed consent. The doctors presumed, I'm not a doctor, but the doctor presumed that the patient consents to the doctor save his life, unless the patient previously says the advanced directive when he say, well, do not resuscitate me in any situation, in any circumstance, and I want to my body and my organs to be used for the transplantation or something like this. And yes, if family and relatives could testify, then he previously, currently, and repeatedly says that I do not want to be resuscitated or something like this, and I act like ordered of do not resuscitated. And in the war context or something, the crisis situation or calamities, as you mentioned, yes, when the person could consent, the consent is important according to international law, but when the person could not consent, this consent, this idea that the person accepts to be saved, and thus is also available.
All right, thank you so much. And the next question is there a moral obligation for states to go beyond legal minimums to protect individuals' right to informed consent?
Well, moral obligation and legal obligation could somehow be different. Moral obligation of the doctor, for instance, is to treat the patient in the better way. But legal obligation in Europe, for instance, contains some standards of care. So the doctor should respect that standards of care, even his own medical consciousness says this and that could help the patient. But most doctors accept his own medical consciousness and not the legal obligation. But in the case of law dispute, the respect of standard of care is mandatory, and he could be accused of malpractice.
Okay, all right. So there are, a lot of questions that were already answered during your session. One that I would like to ask you is, how does the concept of informed consent apply to emerging fields like AI, genetic engineering, or data privacy?
Yeah, these are emergent domain, and in Europe we have an act that regulates the using of data protection, and this act require specific informed consent. It's not called informed consent; it's called simply consent. But the description show us that it's about the idea of informed consent that was taken from this medical field and moved to the field of this protection of personal data, personal information. And of course, in European Union, we have from 2 years or 1 year and a half an AI act, the act with using the AI, but is not yet complete, and at the moment fail to respect the right of autonomy in using the artificial intelligence.
Okay, so our next question, probably the second last one. What safeguards are recommended for obtaining consent from refugees or asylum seekers undergoing medical procedures?
Well, first of all, the patient should understand exactly. So the language should be the language in which the information are present. If possible, should be a language that this refugee understand better. But sometimes somehow this is not possible. So a doctor should do his best to inform the patient, but sometimes they do not. There is not possibility to have a translator or a person that know both language, or and sometimes this is not possible. But the doctor should explain to the patient as good as he can, and to do all effort that he can do in the particular circumstance of the treatment that he perform.
All right. Thank you so much for such a wonderful insight. Now, the last question that we will take is, what lessons can be learned from cases where informed consent was violated but no legal remedy was granted?
Well, there is many cases in which this is the legal case, the litigation was due, and sometimes the patient even win the process, but or his family win the process because the patient was died in time. So the understanding are for the future, because somehow the patient the damage is already done. But we should understand the imperative of using informed consent in medical scientific life, and now in the new technologies, in the using of AI, as we previously mentioned, that even in Europe, the Europe consider themselves to be most development for other countries, such as United States, for instance. But even in Europe, the legislation failed to well documentate this using of informed consent in IE relationship.
All right. So thank you so much for answering all the questions and for the wonderful session, because as per the comments, our students loved it and they gained a lot of insights from you. And again, on behalf of everyone present, I would like to thank you, and we all hope to see you in another session.
Thank you very much. Thank you very much. And I'm glad to be here with you, and I'm always available to another session, and to present another topics when I can, and we will communicate with your university as soon as we can.
That is so kind of you, sir. Thank you so much. And thank you to all the students and participants for being here with us in the session and being so inquisitive for all the things that sir has to share. So we will all see you in the next session. Till then, goodbye.
Thank you very much, and thank you to all of you, and have a nice, a wonderful day.